Welcome to Future Knowledge, a podcast about knowledge, creativity, and policy, brought to you by the Internet Archive and Authors Alliance. Every creative act builds on what came before it. Stories, ideas, sounds all get integrated into our culture and remixed over time. But in the information age, the rules governing who can use that shared material are quietly being rewritten, often expanding ownership while shrinking what belongs to everyone. If creativity and innovation depend on a healthy cultural commons, what happens when that commons keeps getting walled off? Hi, everyone. I'm Chris Freeland. I'm a librarian at the Internet Archive. In the public domain, legal scholar James Boyle helps explain why the public domain, the shared pool of knowledge and culture we can all use freely, is essential, and in fact, just as essential today as when he first published the book in 2008. Jamie will be in conversation today with noted copyright scholar Molly Shaffer Van Houweling. So as we get started here, I'd like to welcome Brewster Kale, the Internet Archive's digital librarian.
Thank you, Chris. I'm so excited about this. Favorite part of the year is the freeing, after almost 100 years, of wonderful works into the public domain so everybody can use it. The Internet Archive celebrates this on January 21st of this year with an online gathering during the day and a in-person gathering at night in San Francisco. Please come. Completely fun. So thank you, Jamie, for keeping the light alive on the value of the public domain. Looking forward to this conversation.
Thanks, Brewster. And here to introduce our speakers and to set the stage for today's discussion is Dave Hansen, the Executive Director of Authors Alliance.
Thanks, Chris. Hi, everyone. I've been looking forward to this talk for a long time. So I will do just some very brief introductions and then get out of the way. So Jamie Boyle is the William Neal Reynolds Professor of Law at Duke Law School. He is the founder of the Center for the Study of the Public Domain, which does great work all year long, but particularly around December of every year, where Jamie and Jennifer Jenkins and the crew with the Center for the Study of the Public Domain remind us about all of the new and interesting things that are entering the public domain. His newest book is called The Line: Artificial Intelligence and the Future of Personhood, published by MIT Press. And we actually did a really fun talk with Jamie on that book. I guess that came out last year, and the podcast episode is out, which you can download and check out online. So in conversation with Jamie will be Molly Shaffer Van Houweling. I had to really condense her intro because I could have gone on for a long time. She is the Harold C. Hobach Distinguished Professor of Patent Law and Intellectual Property at UC Berkeley School of Law. She's the co-director of the Berkeley Center for Law and Technology. She's one of the founders of Authors Alliance. She was the associate reporter for the recent ALI Copyright Restatement Project. I could go on for several more paragraphs, but I think you get the point that Molly knows quite a bit about copyright law, the public domain, and how that system of laws affects the creation and dissemination of works. So I'm really excited for this talk, and I will get out of the way. I'm going to turn it over to Jamie, and he's going to get us going.
Thanks very much, Dave. This is incredibly exciting. I mean, first of all, authors always wonder if anyone reads their books at all. And for me to be talking about the book 17 years after it was published, next year it's going to be able to vote. That's a great feeling. More so because some of the people introducing me are my heroes. Molly is one of my heroes. I worked with her as an academic on Creative Commons, supported her, tried to support her work with wonderful work with Authors Alliance, admired her scholarship. Chris and Dave are longtime friends and colleagues. Brewster is just one of my heroes and has been for a very long time. And the Internet Archive and Authors Alliance just really deserve your support. They are two institutions that just do unmitigated good in the world, and everything you can do to support them and to learn more about them, you should. So Molly's going to explain, I think, and has some incisive questions about it, but I'm going to start by just reading the opening words from the book, because I think that might help us set the stage. I was writing a book in 2008, trying to get people who were then going, oh my God, the internet, spam and porn, and pretty much nothing else. That was all they could think about the internet. And I was writing, trying to get people, not lawyers, just actual people, to think about intellectual property. And so that turns out to be a really challenging task just for a writer. So this is how I began. Each person has a different breaking point. For one of my students, it was the United States patent number 6004596 for a sealed crustless sandwich. In the curiously mangled form of English that patent law produces, it was described this way: a sealed crustless sandwich for providing a convenient sandwich without an outer crust, which can be stored for long periods of time without a central filling from leaking outwardly. The upper and lower fillings are preferably composed of peanut butter, and the center filling is comprised of, at least, jelly. But why does this upset you, I asked. You've seen much worse than this. And he had. There are patents on modified human genes, on auctions, on algorithms, on business methods. The U.S. Olympic Committee has an expansive right akin to a trademark over the word Olympic and will not permit gay activists to hold the gay Olympic Games. The Supreme Court sees no First Amendment problem with this. Margaret Mitchell's estate famously tried to use copyright to prevent Gone with the Wind from being told from a slave's point of view. Congress periodically considers legislative proposals that would allow the ownership of facts. The Digital Millennium Copyright Act, the DMCA, gives content providers a whole array of legally protected digital fences to enclose their work. In some cases, it effectively removes the privilege of fair use. Each day brings some new internet horror story about the excesses of intellectual property. Some of them are even true. With all of this going on, this enclosure movement of the mind, this locking up of symbols and themes, facts and genes, ideas and eventually people, why get excited about the patenting of a peanut butter and jelly sandwich? I just thought there were limits, he said. Some things should be sacred. This book is an attempt to tell the story of the battles over intellectual property, the range wars of the information age. I want to convince you that intellectual property is important, that it's something that any informed citizen needs to know a little about, in the same way that any informed citizen needs to know at least something about the environment, civil rights, or the way the economy works. In the pages that follow, I will try to show you that current intellectual property policy is overwhelmingly and tragically bad in ways that make everyone, and not just lawyers and economists, should care about. We're making decisions that will have a negative effect on our culture, our kids' schools, our communication networks, on free speech, medicine, and scientific research. I don't write this as an enemy of intellectual property. Parenthetically, I'll say I want to stress this point. A dot communist ready to end all property rights. In fact, I'm a fan. It's precisely because I'm a fan that I'm so alarmed about the direction we're taking. Still, the message of the book is neither doom nor gloom. None of these decisions is irrevocable. The worst ones can still be avoided altogether, and there are powerful counterweights in both law and culture to the negative trends I describe here. There are lots of reasons for optimism. I'll get to most of them later, but one bears mentioning now. Contrary to what everyone has told you, the subject of intellectual property is both accessible and interesting. What people can understand, they can change. Thanks.
Jamie, it is such a delight to be joining you here today. I don't know if you even remember the first time we met. It wasn't in 2008 when you published The Public Domain. It was at least 10 years before that when you were a rising star law professor. I was a starstruck law student, and you were already taking the message of the public domain kind of on the road and came to my law school to talk about it. You convinced me to care about intellectual property, to care about the public domain, and even to want your job and to join you, as you've mentioned, in lots of projects since then. So did we fix it? Is there still reason to be worried about the public domain and its health many years later, today in 2025?
That's a very deep question. We fixed some bits of it, and we got some bits tragically wrong. But okay, why care about it? Here's 4 reasons. I was just trying to think, how should I respond to that question? 4 reasons why you might care about the public domain. First, if you care about creative arts. So copyright has a great role to play supporting artists, supporting distributors. But it also has this role in protecting the public domain so that future creators can draw on that to make new, wonderful culture. If you wanted a single story from 2025 that exemplifies this, it's the current suit, the reggaeton lawsuit, which is an attempt by some talented musicians and their lawyers to monopolize the basic dembow rhythm that is the basis of reggaeton. And they are sued 163 recording artists between 2,000 and 4,000 songs we don't even know. And basically what it's saying is we own a genre. And when you hear people saying we own a genre, that's where you can tell that intellectual property is going wrong and we are encroaching into the public domain. Second reason, if you care about science. So again, patents can play a vital role. I believe in patents. I like having new drugs that save lives, and patents can play a role there, though there's some problems they can't fix. But the public domain of basic scientific knowledge is just as vital. And if you want a single example, look at the way that the fight to make government-funded research available to the world at the cost of reproduction, namely zero, look at what COVID taught us about that. Basically, we got scientific knowledge to flow as fast and freely as the awful virus it was attempting to cure, right? And that's what the public domain can do when well mobilized. Third reason, if you care about cultural heritage, and if you're going to an Internet Archive talk and you don't care about cultural heritage, I think you went to the wrong place. So I just think that's a basic point. No one may need refreshing on that. But, librarians have a word for what copyright has done, and archivists, what copyright's done to their field. They call it the 21st century black hole. Copyright pulls in all of these works, most of which are not commercially available, most of which we don't even know who the copyright owner is, makes them unavailable for no good reason, and lock them up right at the moment when we had the technology, which could have made the world's cultural heritage available to the world for nothing. Deep irony. And finally, if you care about economic and expressive freedom, we live in an astoundingly oligopolistic market, a point that I think you and I will come back to. You pick your market and you'll can see oligopoly and monopoly distorting it. And oligopoly and monopoly by themselves are bad, but oligopoly plus IP is an almost unbreakable set of manacles, because people can basically say that any attempt to compete with me, to do to Facebook and Instagram what Facebook and Instagram did to MySpace, is illegal. It's felony contempt of business model, to quote Cory Doctorow. And so I think if you want to be able to take your car to a dealer that isn't the people who made your car, if you want to be able to change the ink on your printer, if you want to be able to change your social network, like all of these things are things where IP can get in the way. So creative arts, science, cultural heritage, and economic, and for that matter, political expressive freedom. Those are reasons we should still care.
So we're going to talk more about some of those current threats, I hope, Jamie, and also rewind a little bit to ask why you were so worried about the future of the public domain back in 2008. But first, let's pause a moment to talk more about what there is to celebrate about the public domain. We've already heard that January 1st, Public Domain Day, is coming up, and the subsequent celebration at the Internet Archive. Authors Alliance also celebrates the public domain, as of course does the Center for the Study of the Public Domain at Duke Law School, which you founded. So what is Public Domain Day all about? Is there something you're particularly looking forward to celebrating this year?
Oh, great question. Well, Betty Boop. I think Betty Boop's arrival into the public domain, at least the 1930 version of Betty Boop, who really surrealistically has just looks like Betty Boop, but has dog ears, and dates a dog chef called Bimbo, who serenades her on a duck that turns into a guitar. I don't know why the Walt Disney sort of corporate wholesomeness sort of dominated in the world of cartoons, but the Fleischer trippy surrealism is something I've always just loved. And so welcome Betty 1.0. But As I Lay Dying, Faulkner, a Somerset Maugham, Cakes and Ale, only a mediocre person is always at their best. Maugham is someone most people haven't read, and you should, because he's as quotable as hell. Outwilds Oscar Wilde sometimes. But I guess we were writing the site, and I encourage you all to go to the public domain site. I think particularly at this moment with AI, the conversation about AI and the arts really sort of dominating our world, what's fascinating for me is that I view Public Domain Day as a time capsule being opened. This is a time capsule from 1930. And what comes out are not just the works of art, which become free, but the lives behind those works of art, right? Machines can make pretty patterns, but they didn't have the life, the experience, the meaning, the pain, the joy that's behind them. And that really comes through for me this year. And Jennifer and I, writing the site, it is mainly her work, really thought that that was the most exciting thing about this year.
So the time capsule analogy is apt because I want you to go back in time to a different set of times when you wrote the book and even before that. So in 2008, you were worried that the public domain was in danger, and some of that danger had emerged over the previous decade or so. But some of it you trace in the book back to 1976. What happened then, or starting in 1976, that changed the shape of intellectual property law, copyright law in particular, that led to some of the patterns that you started to worry about?
Oh, such a great question. Well, and which, of course, Molly knows the answer to probably better than I, because she is a wonderful scholar and you should read her work. But the 1976 Act was the culmination of a series of developments, I'm simplifying, which basically did a bunch of things that had incredible impacts that at the time no one imagined. The first thing is they got rid of copyright formalities, which previously had required you to actually say, copyright Chris Freeland 2025, if you wanted a copyright. And what that meant was that all of informal culture, every selfie you take, every love note you send, every home movie you make, all of these things are now under copyright, regardless of whether you wanted them or wanted that or not. So before that set of changes, which culminated in 76, informal culture simply wasn't inside the world of copyright, right? No one would have thought that a home movie was copyright. And basically that meant that 99% of our culture was outside of IP, and suddenly it was inside of IP. And that's enormously important for any historian, for archivist or documentarian, for all of us, because we are denying ourselves access to our own culture and frequently doing so for no reason. The creators may not have wanted that. The second thing was the term extension. So, as late as 76, we had 28 years plus 28 years. And what that meant was that you could actually get a work after 28 years. And when it came to books, 85% didn't renew. So they said, I don't want any new copyright. It was very easy, very cheap to renew. I don't want to do copyright. So that meant that 85% of the stuff went immediately into the public domain after only 28 years. Now it is life plus 70 or 95 years for corporate works. So bottom line, we suddenly put basically 99% of our culture came from outside of the world of the IP into a system for which it was not designed. It wasn't designed for people either. And we also suddenly enormously extended the copyright term right at the moment in history where we were just about to get a technology which would have allowed us to digitize it all and make it available to the world. I mean, cosmic irony, right? And so that's really what changed in 76.
It's so meaningful to me, of course, Jamie, to hear you talk about automatic copyright, which continued to get even more automatic with even more changes going up through 1989. The shift in the balance of ephemera that ends up copyrighted as opposed to in the public domain is part of what motivated us to work together on Creative Commons, which was designed in part to make it easier for people who were motivated to nudge their stuff back towards the public domain when they got a copyright automatically. But that's another story for another event. Okay, let's fast forward another little bit from 1976 to the period, the run up to your publication of the public domain. What was happening in that decade or so that had you so worried? And in particular, I'm curious about something you refer to in the book as the internet threat.
Yeah. So the internet threat was my attempt to summarize a particular worldview, which isn't entirely wrong, as any pernicious worldview, always has to have a shred of truth. The internet threat says the following thing. The strength of our IP protections needs to be inversely proportional to the cost of copying. So when you need a monk in a scriptorium to produce a copy of Aristotle's Poetics, nobody needs IP because it's basically a good, just like a cup of coffee. When you have the Gutenberg press, then we start thinking about having copyright protection, although we don't use it for 200 years or more than 200 years after that, 300 years after that. And the internet threat says, when you get to the world of the internet, where the cost of copying has fallen almost to zero, inversely, IP protection should move asymptotically towards perfect control. In other words, the easier the copying, the stronger the rights. And that view was held sincerely by lots of people who wanted to introduce a set of changes, some of which would have destroyed the internet as we know it today. As you know well, introducing strict liability for all acts of reproduction, regardless of whether you knew it or not, and with any transitory copy counting as that. And as my student subject say to me, it's like, smiling nicely towards grandpa. It's like, Professor Boyle, that would have made Google illegal. And I say, I know. And it very nearly did. And we came just this close to actually having no protections for mere conduits, no protections for search engines, no protections for social media. And so we would have got basically America Online or cable news, right? We wouldn't have had, in any sense, a free internet. And that was one of the things that I was worried about, although by the time I wrote the book, the immediate danger on that had passed, but its reverberations were continuing.
So, fear about the internet threat almost destroyed the internet's potential as an engine for creativity and dissemination. Let's fast forward some more to today. Are we experiencing an AI threat? Is it similar, different, overblown? Are we missing the AI potential, worrying about the AI threat? What's your take on that?
Oh, I mean, a fascinating conversation, which I love. Maybe we could just schedule like 5-hour conversation between the two of us just to have that. I think there is an enormous threat and enormous potential. The threat, I think, is obvious. In the book, I talk about our 2020 downside vision. We always see with threats and accurately see them. Like, we knew the bad things that would come about the internet. We didn't, I think, understand the good things. I think we see the bad things about AI, the threats to artists, which are real, the deep fakes, et cetera, the cheapening of things that we hold dear. What I think the hope is, and here the public domain also plays a role, is that we have lots of competing forms of AI, and that's by no means a certainty. The big content companies are trying to make deals with the big AI companies. And if you control the content that the stuff is trained on, you can pick winners as to the technology of the AI producing perhaps still another oligopoly. That's a real danger. We need to worry about it. And then the other thing is that the thing that I really hope for is that AI could develop dramatic new scientific advances for which it will need relatively unconstrained access to our scientific archives, towards our data, towards our scientific articles, which, as you know, many of which live behind paywalls. And so, ironically, I think we're so focused on the real threats that many of the things we're likely to do, for example, saying training AI is copyright infringement, are actually maybe more likely to hurt artists, who are the people I really want to help, more likely to give us an oligopoly, more likely to give us a monoculture. And for those of you who are interested in your history, go back and look at the Aeolian Company and what they wanted to do with recorded music in the early part of the 20th century. I think the analogy is precise. Basically, if we control all of the content, we can control the technology. And I think that should make us worried.
Jamie, the questions that you're raising about, what would be the unintended consequences of applying copyright to certain dimensions of our current life, they remind me of another line in your book where you refer to intellectual property as an evidence-free zone. Are we still operating in an evidence-free zone as we try to tackle the challenges of intellectual property in the public domain today?
What I was referring to, thanks, Molly. I mean, that line has actually had some legs. What I was referring to is we make IP in a way that's just really bizarre as compared to every other form of advanced regulation. So if you come up with a new EPA regulation, I mean, when we used to have an EPA, this is like legal history, but when we had environmental protection, you would have to say, okay, here's what the dangers are to human health, right? This is the number of lives that will be saved. This is how much it will cost to do this. And here's at least our best guess at the unintended consequences of the regulation. Will it shift us to something that's even worse, right? And we do that with every form of regulation. With a drug, you don't just have a celebrity coming in and saying, this is a pink drug. I love pink. We would laugh if that happened, right? You have clinical trials that supposedly test it. With IP, you come in and say, if we lengthen the copyright term, there will be more creative works. And a celebrity comes in and goes, I love the songs, they're like my children. And Congress goes, yay, we will extend copyright yet again with no evidence that it will help. Europe actually, to its great credit, passed the database director, said, maybe we should look to see what effect it has. Then he went away and did a study. The study generally indicated, the first study was a guy walking around a bookstore and going, everything looks fine to me, quite seriously. The second study goes, well, actually, there's no real evidence this is helping and some evidence that it's hurting, but they kept the database directive anyway. So no, I think we're still in an evidence-free zone when it comes to IP. But I mean, I guess I was assuming that I could rely on public health and the environment as things that were obviously we would never kick science out of, and they were the baseline I could refer to, that the answers seem to be, hey, guess what? We can make environmental policy and NIH policy just as evidence-free as IP. So it was not really the effect that I was hoping to have in terms of the comparison.
Well, that was depressing. So let's go down that road. One thing maybe that's even worse than an evidence-free zone is a zone of misinformation. And you write about that a bit in the book, too. In your final chapter, you speculate about the possibility that the internet might evolve from the open web, the topic of a recent Internet Archive event, to a more closed network of specialized applications. And you speculated in the book that this might result in fewer scams, less misinformation, but at the same time, you say it would undercut the iconoclastic technological, cultural, and political potential that the web offers. Now, we have in fact seen, I think, the rise of relatively closed applications like Facebook and TikTok, as opposed to, we still have the open web, but as our students don't seem to know about it, but we haven't seen the reduction in scams and misinformation. Instead, we seem to have the worst of both worlds, a diminished open web and more scams and more misinformation. Am I wrong about that? Could it be even worse? What happened to give us this combination?
Well, you've got a Scot here, so I would have to say that it could always be even worse. But I think you put it beautifully, Molly. I mean, I was worrying that we would descend from the internet world into, I mean, I didn't quite use the phrase an app world, but where freedoms are specifically denied to users. And that has largely happened. And I think our students, they've never experienced life or only occasionally experience life outside of the app world. And for whatever reason the app doesn't work, then you go to the open web to find out why it doesn't work or something like that. And as you note, but we haven't had all the benefits. The scams have got worse, the lock-ins have got worse, the manipulation has got worse. So I come back there to the answer, and here this is a link with another great talk that the Internet Archive and Authors Alliance put on with Cory Doctorow, to his points about enshittification, that the problem here, the underlying problem, is oligopoly, that a lot of this can be solved by competition, which is something that, it ought to be something that liberals and conservatives can come together and say, yeah, we might actually be able to agree that being locked into something is bad and having a diversity of voices, a diversity of services is much better. And so I think IP is only one part of that. I think antitrust is an enormous part of it. I think greater cultural awareness is an enormous, activism is important, union labor organizing and so forth. But it is a part, because a lot of the bars that keep you in those apps, those little walled gardens, are forged with IP. And so that's something that I think, could it get worse? I mean, clearly it could get worse. I think the question is whether we are going to have another cycle of creative destruction of the kind that the web had, which, remember, there was this moment of disintermediation, right? Anyone with a great idea can come and put it up there, new apps everywhere, destroy the old social network because it's inadequate on privacy and create Facebook. And so there is the hope that dynamic pressures will be enough, together with government action, to actually make more of that, to give us a new cycle of openness. And I think understanding those IP bars is a key part of that.
I want to circle back to hope, but not yet. I have one more depressing question to ask you about today's environment. Now, throughout the book, you remind the reader that less intellectual property doesn't necessarily mean less creativity and less innovation, in part because there are alternatives or complements to intellectual property that can also provide sources of funding or just the motivation of the joy of creating that generates lots of works. Now, when you wrote, one of the alternative sources of funding especially for expensive discoveries and creativity, was federal funding of science and the arts. This year, as you've already alluded to, we've seen massive cuts to that funding. And so I'm curious, what does that mean for the importance of IP and of the public domain?
It's a great point. I think American science is being damaged in a way that I think no rational person could cheer about, which is not to say that our science funding was perfect, that NIH didn't have bloat, that there weren't problems of conservatism in a non-political sense, that iconoclastic scientists were having difficulty getting funds, that grants took too long, the review process was slanted. All those things are true, right? And we should fix them regardless of what happens. But we took for granted a sort of vision of innovation as a pyramid, and at the bottom layer was this basic scientific research, some of which, by the way, was done by companies, but the vast majority of which was funded by governments. And that was a public good that actually benefited everyone. It's a great deal. The ROI, the return on investment, is fantastic. So it's true that with that in abeyance, there will be a greater pressure on private enterprise to fund things. But I just don't see any world in which private enterprise is going to be incentivized to fund basic research that doesn't have a commercial payoff. So I think we've basically taken the bottom layer of the pyramid and started cutting holes in it. And then we're just hoping that the whole thing won't collapse.
So that makes me feel motivated towards an end that you talked about in the book. That is being part of what you called a cultural environmental movement to save, like, the equivalent of public lands would be the public investments that you were just talking about. So in the book, way back then, you pointed to some emerging organizations that were part of a fledgling cultural environmental movement. I've just suggested already that we still need, maybe now more than ever, such a movement. I'm curious how you feel about that. What's your view of the movement that you helped to inspire? Is it healthy? And if you've inspired folks to care as much as you've inspired me to care, how can they be a part of it?
Well, so thank you. The analogy to environmentalism was this. Though it's hard to believe, the environment was made up. It was socially constructed. If you talked in the 1940s to someone about the environment or environmentalism, they would have gone, you mean the stuff around us? They wouldn't have had the connotation that we had. And if you told them that duck hunters and bird watchers had shared interests in preservation of wetlands, or that someone who cared about pollution in LA had a shared interest with someone who worried about diminished salmon stocks in the rivers of New England, they would have gone, what on earth are you talking about? Nothing links those ideas together. There's nothing that links them together. Now we look at it and go, how can you not see the thing that links them together? It's care about the environment. And so that's something where it was socially constructed. People made something up. They created a thing in their brains that made the world change shape. And suddenly lots of things clicked together, and alliances, concrete political alliances that had never been imagined, came into view. So yes, I think we desperately need such a movement like that. I think we need a movement that is effectively a movement for the common weal, for the open spaces of the mind, a movement that actually tries to say, here are the things that we believe in, which are these building blocks that will make us all better off if we can actually preserve them. Some of that is still the public domain. Some of this is the stuff that you're talking about, a commitment to science, not just to funding science, but to the idea of science, to the idea of scientific truth. And the thing is that we've sort of assumed that those ideas spoke for themselves. Who would be against basic scientific? Like, there's no pro-cancer party. Well, I mean, I didn't think that. Maybe there is. There's no pro-measles party. And so I didn't think that you needed to say, Hal Abelson used to talk about the FDB index. Do you remember this? Fewer dead babies. Like, why do we need to pitch that that's a good idea? But apparently we do. And I think that there are actually a lot of people, I think a majority of people, regardless of whom they vote for, who would say, well, of course I support those things. Somehow we need to find a better way so that those people can find common cause.
I have quite a list. The first one is really keying on the public domain and observes that one of the things that's interesting about the public domain is that when famous things come into the public domain, the result is that we often see works that are probably fair use in the first place. So, for example, Winnie the Pooh as a zombie, right? And the question is, why is that? Why do we have that phenomenon of people like not going quite as far as they could have once these works enter the public domain?
Why don't people immediately just produce low-cost versions of it? They do. It's just that reporters can't say, hey, a lot of really great books suddenly became cheaper because fewer people will click on that than the actual movie. For the Winnie the Pooh one was a slasher movie called Blood and Honey. And a lot of people go, see, that just shows you the public domain's a bad idea. So I think the answer is we do see a lot of those works there, and we see them being produced. But the attention often goes to the transgressive works. The good news is, flip the story around. Shakespeare's always been in the public domain. So do you spend much time worrying about Shakespeare's slasher movies or Shakespeare porn? I think you probably spend more time going, oh my God, I love West Side Story, or I love Forbidden Planet, or I love any of the endless variations on Shakespearean works that are being produced. So I think the good news is we do see immediate diminution of cost, immediate increase of accessibility, including places like the Internet Archive. We also see some creative reuses. The number of Great Gatsby reuses is just exploding. There's, I think, 4 more coming out this year, right? So actually people do that. And I just wish the reporters would stop focusing only on the slasher movies and actually celebrate some of the real stuff that's happening.
So Jamie sounds skeptical about the slasher movies. I took the question another way. Why don't we see more slasher movies based on Winnie the Pooh or Jane Austen or whatever, given that there's a fair use case to be made for those kinds of transformative works? And for those of us who are fans of that, and I think Jamie really is too, of course, one answer is that mentor of all of ours, Larry Lessig, has famously described fair use as the right to hire a lawyer, because fair use can often provide breathing space for free expression and transforming existing works, but it is not always experienced as very predictable. We've seen many famous fair use cases go one way in the district court, another way at the Court of Appeals, and another way at the Supreme Court. And so the public domain, one of the beauties of it is that it brings more crispness and clarity and certainty that you can borrow a little, borrow a lot, be a slasher movie, be some other kind of informative use with no questions asked.
There is apparently a Pride and Prejudice and Dragons that came out. I haven't read it, but in our public domain article, we say that we really hope it has the line in it. It is a truth universally acknowledged that a single dragon in possession of a large hoard of treasure is in need of a wife.
You talked about formalities. That was like kind of a big, shift following the 1976 Act. Why were the effects of removing formalities a surprise to anyone in the United States? The burn countries hadn't had formalities for years. Couldn't they have looked ahead and seen what happened in these other jurisdictions?
I think Molly might have a better answer than me in that. I'll say one thing. First of all, the United States has long said that we adhered to Berne, and then the question of whether we actually adhere to Berne is still a question. For example, do we actually have an attribution requirement under American copyright law? I think it's a great question. Nobody imagined there would be a technology which would have made all of that informal culture potentially available, right? So that there's all of this stuff which could have been shared, which is now in uncertain status. So that I think that's one huge thing, which we never really thought that the effects that it would have because we didn't have the technology which would make it a live case.
I think that's the best take and a fascinating one. And certainly when we worked together on Creative Commons, part of the motivation was just the irony and the tragedy of being at this moment where we had the potential for everyone to harness this technology to share stuff so easily and for free with no strings attached at a time when everything was automatically copyrighted. And the potential part, the harnessing, could not have been foreseen, I think. I mean, there were fledgling networks and maybe someone could have foreseen it, but it's understandable that it wasn't fully foreseen during the decades that we were getting rid of formalities in order to adhere to Berne. And of course, there were arguments on the other side. There were concerns with unsophisticated authors who didn't know about the ins and outs of technicalities, not being able to take advantage of the rights that come with copyright protection because they didn't have a lawyer, they didn't know how to do the paperwork right. And so there was a compelling spirit of author enablement that drove some of these changes. And ironically, it then was not enabling to all of the authors who were truly enabled by the internet and the potential to share their stuff for free, which suddenly came with copyrights that they never signed up for.
And if I could just jump back to our slasher topic, Sterling Dudley has a fantastic blog post, Screams in the Vault, Public Domain Horror in the Age of IP. I definitely think horror and IP should be its own subfield, and I hope there's someone out there who's about to create that.
While we're on comparative law, the question asking about where does the US sit here today? Or is it leading, following, sitting in the middle of the pack, particularly when it comes to the public domain?
Well, there are countries that are or are threatening to expand copyright duration even more than we have in the United States. So that's a threat to the public domain to worry about on the comparative front. I think other countries have done more to try to solve some of the problems that we have alluded to. Problems, we haven't used this terminology yet in this conversation, but the problem of orphan works, of works that automatically have copyright protection that lasts a real long time before the works go into the public domain, often works that aren't commercially viable, and it's hard to even figure out who the copyright owner is from whom you would ask permission. So that stuff that could functionally be in the public domain because no one would care to exercise their rights is not, because that no one who cares can't even be identified. Other countries have done more to try to tackle that problem with various types of legislative solutions. So those are two contrasting examples that come to my mind.
One of the other things is take the pervasive expansion of IP, which it becomes longer and stronger, more penalties, but also more atomic, like it regulates down to a level that we'd never imagined before. You know, you can't sample more than one note, says one appeals court ludicrously. And if you put that together, so just more places where individual human beings who'd never previously been thought to be subjects of copyright law because they didn't have the technology to make acts of reproduction, to make derivative works, whatever. You needed a movie studio, you needed a broadcast tower. We were all suddenly thrust into IP. So suddenly all these people are interacting with IP, and a lot of them don't like it because it doesn't seem well designed for them for the excellent reason that it wasn't, right? If you then add to that, so this greater mesh of potential illegality, if you add to that selective prosecution, selective government enforcement, largely based around who's in favor with the regime, then I think you really have a pretty dystopian situation. Of course, it's selective enforcement of many things, antitrust, export regulations, tariffs, etc. But IP is another thing which touches so many things. And so I think that could change the calculus in a way that I wasn't even thinking about when I wrote the book, which is I was assuming that a fundamental backing of sort of the rule of law, with people being prosecuted just because they had broken the law and not for any other reason. And I think if you add that in as well, I think the United States in short order will undermine dramatically its role as a sort of dynamo of innovation. Because who wants to do business in that kind of environment when you can suddenly know you're no longer a favorite and suddenly you're on the outs? I mean, just look at what happens in Russia. So I think that's a place where our status in the world is really being challenged.
That's so interesting. I have often thought about, and my students are always shocked by finding out how many things are copyright infringement, that, or at least prima facie copyright infringement, that they do all the time. And so I'd often thought about the fact that the potential for copyright infringement in today's technological environment, where we all have the tools to do it literally at our fingertips, that the potential for infringement is ubiquitous. The vulnerability that creates for the exercise of prosecutorial discretion, I think that's always a dangerous combination, and I hadn't thought about that particular combination in this context, and that's another terrifying thought.
I have one more negative one, then I'll ask you a positive question. How can there be both copyright and license restrictions? What's the balance? Licenses don't ever expire. I want to expand on that a little bit, because one thing that I really worry about is that we're seeing a real enclosure movement on the web, but it's an enclosure movement that's not driven by copyright law. It's driven by all of these other kind of ancillary tools like license restrictions, the use of DRM or robots.txt exclusion headers, things like that. And do you worry about that? Have we moved into an age where copyright really is not the tool that's limiting us, but all of these other kind of privately created and administered tools are kind of run amok.
Yeah, very much care about it. So one of the ways that the courts sort of initially messed this up was deciding that just loading software into RAM, in other words, running a program, counted as a copy, and then immediately every licensor of software, which is everyone, none of you own any software unless perhaps it's open source. This is great because now that means I can tell you to do whatever the hell I want. You must wear a Duke hat when you run my program. Otherwise, it's copyright infringement because that was an unlicensed copy. And luckily, the courts have sort of pushed back on the worst aspects of that by trying to say what counts as an actual violation of copyright. But as you note, Dave, it doesn't need to be copyright infringement. And what's more, other things could be invoked, such as the Computer Fraud and Abuse Act, to say that basically violating the terms of use on my website is just the same as if you were a hacker hacking into my system with malicious intent. So I definitely think that those terms of use are a real threat. And I have to say, again, trying to lead us onto the path of optimism, it's another thing that speaks to the importance of focusing on competition. Because often the best answer to that is, I'm not doing business with you. Your terms of use are terrible. I'm going next door. But if you can't, because they've got your data and they've got your network and you're locked in by the chains of network effects, then the classic modes of registering are voice or vote and exit, right? And if your voice is limited, your vote is hard to have an effect on these issues and you have no power of exit, then I think you're in trouble. But I think there is the beginnings. I think Lena Khan and the FTC in the last administration, the new focus on antitrust enforcement, consumer movements, the kind of stuff that Cory Doctorow is always agitating for. I think there is a burgeoning movement that says, why are you telling me what I can do with my own tractor? And if you can get Iowa farmers pissed off about the restrictions that are being put on them, then I think you have the beginnings of a political movement of actually tying very diverse people together, which links back to the environmental movement.
I will just add, also on a relatively optimistic note, that the doctrine of copyright preemption, which is one of the doctrinal tools that limits the extent to which we can layer breach of contract and misappropriation and other theories on top of copyright, it has been reinvigorated in recent years. And courts have, in fact, refused to enforce terms of service. There's a case coming out of California, the federal courts in California, called Bright Data versus X Corp, which is about X Corp's attempts to use license restrictions to say who can have access to the publicly available data that they pump out there. And the court has said that enforcing those is preempted by the Copyright Act because the Copyright Act has all these limitations. The Copyright Act has the public domain, and enforcing license terms would sometimes endanger that. And the courts have recognized that that's a conflict and we shouldn't put up with that. And sadly, courts for decades have not been recognizing that, but they've really started to, which I've found refreshing and helpful.
All right. What's one thing that you would tell these young people that they should know or learn?
First of all, they should get a copy of Jennifer Jenkins' Copyright, Creativity, and Culture aimed at exactly that class, and or download our comic book, Theft, A History of Music. I think the thing that I would want people to understand is that the copyright system is, I don't think, working terribly well for musicians. I think it puts them at disadvantages. And it also doesn't actually work well for the music business because it makes innovation incredibly hard. Just getting the kinds of licenses to set up Spotify and so forth is very difficult. But I think that if you understand it just, at a basic level, then you have a lot of tools and you can avoid some of the terrible mistakes that musician friends of mine have made, where they just didn't understand what they were signing away. They just didn't understand the implications of a simple act. And that stuff is one of the reasons why at our center, we're so passionate about actually telling people what their rights are so that they can actually exercise them rather than finding that they are the victims of them.
I would add to remember when we think about copyright and debates about copyright and intellectual property more generally, that if what we care about are artists and inventors, the creative humans and innovative humans that are empowered by these sets of laws, we should recognize that they are often not the owners of the rights in the things that they have created. And so even if you thought that the person who invented reggaeton should own reggaeton, giving them the copyright to it would probably mean that it would ultimately be owned by a record company or a private equity firm that ended up acquiring the record company, and the creator of reggaeton would be precluded from making reggaeton because it would be owned by someone else who might not give them the permission to generate music in their own style. So as we think about who are the winners and losers and what we're fighting for when we fight for cultural environmentalism, that's something that I try to drive home for my students.
Thank you, Jamie, and thank you, Molly. This has been such a good conversation. I really appreciate it.
I heard that there was a possibility of a 5-hour conversation about AI and copyright, and I would say that I would be front row for that. So I'm going to invite you all back for this 5-hour conversation. Maybe we can do it in 2026. Big thank you to Jamie and Molly for a fascinating conversation, and to Dave Hansen and Authors Alliance for facilitating and for co-hosting our session. Thanks, everyone. Have a great day. Thanks for joining us on this journey into the future of knowledge. Be sure to follow the show. New episodes drop every other Wednesday with bold ideas, fresh insights, and the voices shaping tomorrow.